All welcome. Let me welcome members of the committee. Honorable members, you are welcome. Stakeholders who are going to make submissions, those who are in the platform, you are welcome. And those who have already made written submissions and send them to us, you are also welcome wherever you are. Welcome the support team from Parliament, including the PBO. Welcome the media, welcome the public at large. Apologies. Do you have apologies, Alan?
Dr. Dion George, on your apology, Chair.
Dr. George has apologized. Also, while we are talking about Dr. George, the other time he raised an issue about holding committee meetings in Cape Town, in the parliamentary precinct. Actually, that's what we're supposed to do. I don't think there's anyone who's opposed to it. However, stakeholders have always been raising the issue of the accessibility of this committee. If you remember, at some stage we had a discussion in the Good Hope chamber when we were having a meeting there, that it's like our public hearings are more elitist because only those who could afford to fly to Cape Town and pay for accommodation were able to access us. So many stakeholders got a relief with the advent of technology, whereby we're able to hold the meetings through Zoom or a Teams meeting, as they only spend money on data. Be that as it may, this is a work in progress. You remember it was raised even in the National Assembly, where the speaker said, we're all looking at it, whether we can have a full member complement of the National Assembly in one place, but we know what has happened as a result of fire. So it's a work in progress. It's a matter that we are looking at, and it will be addressed. Item 2, public hearings on the general laws, anti-money laundering and combating terrorism financing amendment bill, B18/2022. We have invited stakeholders to come and participate in making inputs or submissions. Public participation is a cornerstone or a pillar of participatory democracy. What it means is that those who are affected by the decisions have got the right and the responsibility to be involved in the decision-making process. A matter that we are processing today is a very serious matter. It has got serious impact on business, on a number of other areas. So it's an issue that we have to converse with the stakeholders, and in particular, South Africans. So it is against that background that we thought, as much as we have got international obligations to comply with FATF, here at home, stakeholders and the public at large have got a very serious interest on this bill, and their inputs will be considered. I know that also the time frame that we have allocated for the public participation has been shorter than what it was supposed to. Honorable de Villiers, for instance, has sent me an email that he got complaints from his constituency that we have allocated little time for this public participation. So that is considered. Let's see how we deal with this matter moving forward, so that we are not seen like we are short-circuiting processes as a parliament. It's like it's a by-the-way issue. It should not be the by-the-way issue of just compliance, but it should be that the inputs that we get from public will be considered. So let's move to item, in item 2. We'll start with COSATU and all those structures, stakeholders who are there. Each structure or stakeholder is allocated 10 minutes. Yeah. COSATU, are you there? Yeah, I've got 10 minutes. If it's Comrade Matthew, you know very well how we deal with the issue.
Morning, Chair.
Or Saktu.
That's right. Morning, Chair. Thank you very much.
Over to you, Etienne.
Thank you very much, Chairperson. Chair, we appreciate the opportunity. I hope that you can see the screen and that the presentation is clear to all the members.
Yeah, we can see the screen.
Thank you, Chair. So we're making a submission this morning on behalf of COSATU and one of its affiliates, SACTU, on the bill. This is a crucial matter for us. You mentioned the importance of it. It's crucial for several reasons that we'll set out to you today. Firstly, Chair, we welcome government's tabling of this bill at the National Assembly. It's a positive step forward by government to address gaps and weaknesses in our existing legislation, which hampers the nation's ability to deal with money laundering and terrorism financing, and to ensure that South Africa is able to avoid a consequential grey listing. Whilst COSATU and SACTU support the bill, we are concerned that the bill in some instances is not sufficiently clear enough with regards to the definition and disclosing of beneficial ownership. And Chair, a lot of our submission will focus on the matter of beneficial ownership, and we will explain it in a little bit more detail later on. South Africa has felt the consequences of treating corruption, state capture, tax evasion, money laundering, and the financing of terrorism with kid gloves. It's only now that we're beginning to turn the corner in the fight against these cancers. Corruption and state capture have cost the fiscus billions of rands lost to criminality. And we set out here in a little bit more detail, Chair, how it's affected workers specifically. It's meant that billions more spent on bailouts for collapsing SOEs and municipalities. It's diverted funds needed for public services that workers, the poor, and the economy depend on. It's forced the state to raise taxes further, leading the salaries of workers and suppressing economic growth. And then many workers have lost their jobs, have not received wages, and have been denied increases. And then finally, what we're also seeing is that austerity budget cuts, as a consequence, further stifle an economy that's still struggling to recover from COVID-19. So you've spoken a little bit about the framework within which this bill is being tabled. United Nations have identified the framework and requirements for member states to contribute towards dealing with the threats of money laundering and terrorism financing. Any member state who fails to do so will be grey listed. Now, this will come with consequences, and it's not only administrative restrictions, but more critically, will make it much more difficult to attract domestic and foreign investors who will be reluctant and at times barred from investing in a market deemed to be grey listed. This is a scenario that workers struggling with a stagnant economy, an unemployment rate of 44%, dwindling manufacturing industries, a flood of cheap imports, capital flights, etc., simply cannot afford. Chair, before we get into some of the amendments that we're proposing, just one matter we wanted to deal with. The enhanced transparency provisions in this bill are motivated by our possible grey listing, but it's also based on the recognition that corporate activity has wide social impact, which is why the Companies Act, for instance, already grants strong rights of access through a broad range of company information. Chair, we believe that some submissions that you'll receive, some presentations that you'll receive, will urge you not to go this far in making company information public, because there'll be an argument that this is a private matter. But the Constitutional Court found different in 1996. It found that the establishment of a company as a vehicle for conducting business on the basis of limited liability is not a private matter. It draws on a legal framework endorsed by the community and operates through the mobilization of funds belonging to members of that community. Any person engaging in these activities should expect that the benefits inherent in this creature of statute will have concomitant responsibilities. These include, amongst others, the statutory obligations of a proper disclosure and accountability to shareholders. So, Chair, we highlight this point because some submissions may well complain about information being made public. Chair, we'll quickly deal with a couple of amendments. The details of these amendments, including the specific wording that we're proposing, is in our submission. We've only chosen a few, taking into account the time constraints. Firstly, with regards to the definition, by its internationally accepted definition, a beneficial owner should always mean a natural person, a human, and nothing else. Without a reference to a natural person, only the first layer of ownership may be pierced, and the actual owner may never be revealed. The bill needs to ensure all layers are pierced to find the actual natural person who benefits from the shares. And Chair, just to give you our understanding of this, often when workers try and establish who owns the company that they are employed in, they will be told, no, another company owns that company, or a trust owns that company, and they can't ever reach the actual human. What this bill seeks to do is show who is the actual human benefiting from the company who may be involved in terrorist financing, in tax evasion, and in money laundering. And so we think it's important that Clause 52, paragraph B of the definition of beneficial ownership should be amended. Currently, it says that the definition includes, but is not limited to, a natural person. This needs to change so it only refers to a natural person. Chair, we also would further propose that the bill should only introduce a single broad definition of beneficial owner within the FICA Act. Secondary legislation such as the Companies Act plus Property Control Act, etc., should not seek to alter or expand the definition, as this introduces regulatory uncertainty and creates loopholes that can be exploited. We should rather have one broad definition within the Financial Intelligence Center Act than try and add to it in the different secondary legislation. The next proposed amendment, Chair, that we're talking to is around publishing information. The bill attempts to improve beneficial ownership data access for law enforcement agencies by mandating the creation of various registers, including in Clause 53, a beneficial ownership register for companies within the CIPC. We note with disappointment that the bill does not seem to seek to make beneficial ownership registers publicly available. It includes a reference in Clause 53 to making annual returns available electronically, but it's not clear to us, Chairperson, that this would mean that such annual returns would then be publicly available. FATF has listed the requirement of making beneficial ownership information publicly available in their guidance on transparency and beneficial ownership as part of understanding the risk associated with legal persons, and particularly in respect of companies' registers. By making beneficial ownership information publicly available, unions, shop stewards, workers, civil society, and journalists can continue to assist in the fights against tax evasion and corruption. This will help to effectively implement a beneficial ownership regime, not just to tick the box. Chair, with regards to the publishing of info, by not making registers public, we run the risk of such registers being stuck on hard drives and servers in the department somewhere without any scrutiny. This would be ticking the box of collecting information, but would not help to win the fight against the tax evaders and the corrupt. Accordingly, we propose amendments to the bill to ensure public access to beneficial ownership registers. Clause 53A and B of the bill, which proposes amendments to Section 33 of the Companies Act, should require proactive disclosures in respect of annual returns. We also support the information about trust beneficial ownership being made available publicly. Trust beneficial ownership records at the Master's Office should mirror how companies' records are envisaged in the bill to be published and made available annually, but also when updated. Chair, the second last slide regards personal data. Now, some may say to you today in presentations and make submissions to you to say that there are concerns about personal data protection and privacy laws when responding to our call for a public beneficial ownership register. In South Africa, privacy and data protection concerns are given legal effect through POPIA. This act may be used as an excuse to block the publication of beneficial ownership data. Yet sections 37 and 38 of POPIA list a number of grounds on which processing of personal information is not a breach of the processing conditions in the Act. These include, for instance, where the public interest outweighs the interference with privacy rights, prevention, detection, and prosecution of offences, fostering compliance with legal provisions, and protecting the public against financial loss due to dishonesty and malpractice. Any of these grounds could be relied upon to substantiate publishing beneficial ownership data when concerns are raised regarding privacy rights and data protection laws. Chair, in conclusion, we welcome the bill and its provisions as a positive step to ensuring that South Africa remains in compliance with its international objectives and avoid a possible grey listing. COSATU and SACTU believe that the provisions of the bill, including those to ensure greater transparency of the actual owners of companies, will help to address serious gaps in our existing legislative framework and to further capacitate the state to tackle corruption, tax evasion, money laundering, and terrorism financing. When company ownership is opaque, these crimes thrive. Workers cannot afford for government to be soft on crime in both the public and private sectors. Failure to deal with these cancers eating at the heart of the state, the economy, and our fabric as a nation are dire. While COSATU and SACTU support this important bill, it's critical that the gaps that we've identified in our submission and in our presentation with regards to the definitions and provisions dealing with beneficial ownership be addressed by Parliament if the bill is to meet its progressive objectives. Chair, thank you very much for the opportunity.
Thank you, Etienne, and also for sticking to the time allocated. Let's take the next stakeholder, Amabungan and Corruption Watch. 10 minutes.
Thank you, Honorable Chairperson. I just want to confirm that everyone can hear me on the call.
Yes, we can hear you and we can see you.
All right, thank you very much. Good morning, colleagues, and to the public at large. My name is Sinan Mirzoyev. I'm appearing together with my colleague, Caroline James. We represent Corruption Watch and Amabungani jointly. We have made written submissions to Parliament, and so that will really contain the bulk and the detail of our submissions. However, we would just like to draw the committee's attention to specific provisions that we found might need particular attention. I might start by saying that on the whole, we welcome the sort of efforts to tackle these particular egregious issues around beneficial ownership, and obviously highlights the important role that access to this sorts of information can help in terms of advancing the fight against corruption and making life easier for investigative journalists in terms of trying to stymie the sort of endemic issue that we've seen in recent years in the country. So in terms of sort of the background to our submission, in July of this year, Corruption Watch participated in a national risk assessment together with the Financial Intelligence Center and prepared a detailed report, basically providing an overview of the legal landscape and framework within South Africa, but also explaining the various risks that we're seeing on a practical level, also looking at experiences that investigative journalists on the ground, such as those from Amabungani, had experienced in terms of their efforts to uncover certain elements of state capture. And based on those experiences, we came up with a series of recommendations. That then culminated in that research report that we submitted in July, and that has been appended to our written submission. So we would draw the committee's attention to the details contained there for additional context. So in terms of our submission, we are going to be focusing on primarily the definition of beneficial owner, and I think it sort of keeps the same tone of the previous presentation. in the sense that we really wish to see a consolidated approach to this. So what we've done here is we've created a side-by-side comparison of the current definition of beneficial owner in the Financial Intelligence Center Act, as amended by the 2017 amendment. And we've done the side-by-side comparison between that and the latest amendment proposed in the bill. In terms of that, we referred specifically to a guideline published in 2021 by Open Ownership, which provided effectively 7 different criteria against which a beneficial ownership definition can be assessed. This is, of course, in line with the recommended definition by FATF. And so, obviously, as you can see here, on our assessment of how South Africa's definition, as it stands, complies with this guideline, 4 out of the 7 boxes are ticked. The beneficial owner must be a natural person. Definitions must cover all forms of ownership and control, including ownership that can be held directly or indirectly. There must be a single definition in primary law. The definition should be sufficiently broad. There should be low thresholds, risk-based approach with a sectoral focus, and clear prohibitions. I'll explain what each of that means in a moment. When we look at beneficial owner as it's defined under the bill currently, you'll see that we find ourselves only ticking 2 of the boxes. So again, the written submissions do flag some of the concerns that we've raised, but one of the issues is that the beneficial owner must be a natural person. In the bill, it specifically says under clause 15 that beneficial owner is including but not limited to a natural person. So obviously on initial reading, that would suggest that it could be something more than a natural person. And our submission is that this can never be the case. The internationally accepted standard is that it must always be a natural person. And so as a result of that, we would implore the committee to pay particularly close attention to that. We also highlight the fact that there must be a single definition in primary law. One of the efforts of the bill is that, and it seems like it seeks to comprehensively tackle the issue. However, in this instance, we would submit that less can be more. A simple definition would be preferable to one that has all sorts of caveats, or for instance, a Trust Property Control Act definition that accepts the FIC definition, but then seeks to expand it. The same thing happens with the Npo Act and the Companies Act amendment. So all of these different definitions obviously create more confusion rather than resolve issues, or at least have the risk of creating that confusion. And so we would submit that a clear and simple definition in the primary law, in the Financial Intelligence Center Act, should be preferred. And secondary legislation, so if the Companies Act is going to refer to it, it shouldn't amend the definition, but rather if it wants to have a risk-based sectoral focus, such as focusing on companies, it can look to incorporate those elements, but really it must be quite succinct. And again, as I said before, less is more in this instance. So that was really sort of a bulk of our submission focuses on the definition of beneficial owner. And I would refer the committee to our written submissions in that respect for far greater detail. I'll focus on some of the other definitions or some of the other recommendations that we've made. And again, just touching on it lightly with the hope that obviously the written submissions will provide the necessary context and detail. So as I mentioned before, the single definition of beneficial owner in primary legislation would be preferable. We do note that in October 2021, the Companies Amendment Bill was tabled or was sent out for public comment. We're not aware of what has happened since then. I understand that perhaps it is somewhere in NEDLAC's processes, but it has been nearly a year since that bill has been tabled. And in that bill, there was a true owner definition, which again referred to the FIC's definition. Our submission would be that there should be some sort of cohesive coordination in terms of that amendment that we understand is in the pipeline, and this proposed amendment to ensure that we're not really fragmenting things to the point that nothing is congruent. The second recommendation that we have is the consolidation of beneficial ownership registers. What we mean by that is the bill proposes an amendment to the Trust Property Control Act, whereby the master will receive information or beneficial ownership information regarding trustees. Our submission is that currently the Companies Act would already compel that in terms of the proposed amendment, and that this needs to be consolidated. There's no use in having data sources in different parts of government that cannot speak to one another, because that would undermine or subvert the entire purpose of having a beneficial ownership regime, which would really be that in many instances, when one is unpacking complex structures, a company can lead to a trust, which can then lead to another structure. And the idea is that all of that data needs to be housed in a singular location. And our submission is that the bill should accommodate that possibility. So whilst the master might be collecting this data, there should be an express provision to the effect that this data must be shared with some sort of central repository. And our submission is that as the CIPC already has the company's register where it keeps directorship information, it would probably be a safe and natural home for this. Our third recommendation is the prohibition of nominee arrangements. So we note that under the bill, there has been a sort of a concerted effort to try and regulate how nominee arrangements are made. And we understand why this is. Obviously, during the years of state capture, some of the most egregious offenses were committed through the use of nominee arrangements. So that would be where someone is acting as a nominee of a shareholder, of a director, and basically acting on that individual's behalf, making it impossible to identify the individual on whose behalf actions are being taken. So in the bill, obviously, there's an attempt to try and regulate this. However, our submission is that, and the latest FATF guidance that has been released on this has suggested that nominee arrangements must be extremely strictly regulated, and in the absence of that, altogether prohibited. Transparency International also calls for a prohibition of nominee arrangements internationally. Thailand and Indonesia have looked to prohibit nominee arrangements. And in Scandinavia, we're also seeing there's been an approach to prohibit nominee shareholding. So I'll just draw the attention to that, but that is something that's quite critical, and we would implore the committee and parliamentarians to pay particularly close attention to this. Then the last three recommendations before I hand over to my colleague, as I see I'm sort of eating up the time, but would be to strengthen administrative sanctions to improve compliance. And what we mean by this is that one must evaluate the cost of compliance versus the cost of non-compliance. And if the administrative sanction is less than the cost of non-compliance, or the cost of compliance rather, then that means that the sanction isn't sufficiently effective. So we would say at the very minimum, it should be sufficiently serious in terms of the amount of fines or penalties imposed, which we see as 5 million for natural persons and 10 million for corporate entities. Alternatively, the reinstitution of the offense, or rather the retainment of the offense, that would carry a sort of a fine or a term in prison. The second, or rather the fifth recommendation, is disqualifications for trustees and Npo directors should be commensurate to other legislation. So we note that delinquent directors currently have a minimum sentence of 7 years. The proposed bill carries only a sentence of 5 years. And the offenses on which one can be disqualified from being, for instance, a trustee of a trust is quite egregious. We have issues like fraud and dishonesty. And so our submission is that the sanctions should be commensurate. And finally, the call for publicly available registers, which I imagine is going to be a common call. But on a practical level, there's a lot of concerns around the cost of compliance for business. But our submission would be that once this data is out, there's actually easier access to that information that lowers the cost of due diligence and compliance checks for the private sector. So there's a benefit in the private sector. For government as well, for law enforcement, the cost of investigating various structures is quite high. By putting that investment in to ensure that there are comprehensive registers digitally available and made public, we can ensure greater accountability. And on that point, it's a good segue to my colleague, Caroline James from Ambabungani. Thank you.
Thank you, Sinan. Good morning to the committee and all other participants. I will just very briefly go over the
Hello.
Yes?
You guys were allocated 10 minutes, and I see you are allocating yourself platforms. How do you want to manage this presentation? You should have shared the 10 minutes. So,
okay, is our 10 minutes completed?
Sanan started at exactly 19 past, and then by the time he finished, it was 29 minutes past. So, okay, take 3 minutes.
Okay, I'll be very quick and go through it in 3 minutes. So what I just wanted to highlight is how important the need for public disclosure of beneficial ownership. And if we go back to the purpose of providing the beneficial ownership data is to prevent financial crime. And our submission is that the only way that this can be done is with the public disclosure of the information. As Sanan mentioned, we would like to see a consolidated register, which would mean it's easily accessible and usable for all stakeholders. This assists in the implementation of the beneficial ownership regime through monitoring corruption and financial crimes, which would be done by law enforcement, the private sector, civil society, and the media. And we have had experience of how difficult it is to access information about companies that may be engaged in corruption without the information that is publicly accessible. As Saktu stated there, this isn't a violation of PAPIA, because our argument is that the important information is just what will be able to unambiguously identify beneficial owners. That information can be determined through regulations, as we recognize is set out in the bill. And that information will then be able to demonstrate what the regulations should indicate, what information can be disclosed, what information is not being publicly disclosed, and the justifications for that. And we also call for public participation in the drafting of those regulations to ensure that the information to be disclosed will allow for this unambiguous identification of beneficial owners. What we are also calling for is the need for proactive disclosure, so that there would be an obligation on entities collecting the information to proactively disclose the information on both an annual and an ad hoc basis to ensure that the information is accessible to all stakeholders who will be involved. But that also means that there is not, that doesn't remove the opportunity to request access through the existing channels, but also as to be set out in the bill. We are calling for the bill to indicate that there should be access for public access. The last aspect that our submissions focus on is the impact of the bill on the operation of NPOs. And our main submission is that the purpose of FATF's recommendations on NPOs is to combat terrorism financing. It's to enable the monitoring and identification of that financing. And our submission is simply that the proposal to have compulsory registration under the Department of Social Development is simply not effective, because they don't have the capacity to conduct full monitoring of all NPOs who apply, as well as they are not experts in issues of financial crimes. So we submit that the registration for NPOs and the regulation of NPOs should be done under existing structures, such as the CIPC for nonprofit companies and SARS for public benefit organizations, as they already have the structures as well as the expertise to monitor and identify risks of financial crimes. Our final submission in respect of NPOs is that any amendments which impact on the operation of NPOs in the country need to be done in full consultation with the NPO sector. There's a great variety of NPOs operating in South Africa, and a compulsory registration would have a drastic impact on their ability to function. And so we do call on the committee to ensure that any impact on the operation of NPOs is done through consultation with them. I think I've gone slightly over my time, but thank you very much for the indulgence, Chair.
Okay, thanks, Amabungan and Corruption Watch, for your submission. Let's move to Npo Working Group. Over to you.
Oh, good morning. Good morning, everybody. Thank you very much for the invitation. A little bit about the Npo Working Group. We came together only a year ago to look at the amendments to the Npo legislation, and now we're looking at this monster of an octopus that we've put on our slide there. What we want to reassure you is we want to be supportive, and we want to participate in this in a very positive manner.
Good morning, thanks, Anne. I think we need to do speed presentation this morning. So I'm just trying to click on my next slide here to make it go. Sorry, here we go. Okay, so we recognize the urgency and we recognize the need for this bill in order to avoid grey listing. One of the major factors that I don't know that the NGO sector is yet clocked is that the foreign donor funding which comes into this country is going to be maybe the first place that grey listing will hit. And it's terrifically important that this bill does go through. But if I can just refer, Chair, to your earlier comment and say that just certainly from the NGO sector, There is a call for an extension and further, even if it's only, we understand the time constraints, but even if you officially only say another week is given, just because it's such a bill to wrestle with, there's nuance, there's so much detail from the nonprofit sector, and there's been very little time in order to engage people and build awareness and get people's input. Our summary of our suggestion is that, and thanks to the colleague at Omegan for already mentioning is that only the required things that need to be done to avoid the grey listing are done at this time and in this bill, just to make sure that we don't have a collapse of funding, and that there are certainly longer term and broader implementation and accountability and transparency and good governance improvements which can be made in the nonprofit sector. However, they cannot be done in this very short time frame and without consultation. If this bill tries to go like a sledgehammer and enforce mandatory universal registration, there's going to be an outcry from the sector, and this will also have a negative impact in terms of grey listing. So if I could just focus first on pulling out the FATF recommendation 8, which is around the nonprofit sector. FATF calls for a focus on the actual risks, and its functional definition of nonprofits is legal person or organization, primarily involved in fundraising, dispersing of funds, and for some purposes. So the first point we made is that this doesn't apply to the nonprofit sector as a whole, and a targeted approach is recommended. And so far, and I'll come to the detail of this, the only so far unregulated part of the nonprofit sector that fits into the FATF functional definition are unregistered conduit voluntary associations. Okay, I'm just going to give you a quick little recap for those who may not be familiar. Most people don't actually understand this. This is what the nonprofit sector currently looks like. There are only 3 types of legal entity that you can run nonprofit activities through: the voluntary association, the charitable trust, or the nonprofit company. And there on the slide are the details of their makeup, their registration, the laws that govern them. All of these cannot be owned, exist for a purpose, can apply at the moment voluntarily for NPO status with DSD, and can apply if they want to for tax-exempt status with SARS. As you will see, the charitable trust is already governed by the Trust Property Control Act, the non-profit companies by the Companies Act, which the Octopus Bill has already got its tentacles on, and which already have all sorts of transparency and disclosure requirements. This area of voluntary associations is the only place that we really need to be focusing on now. Okay. So if you look at what voluntary associations are like in the sector, and the point we make here is that there are just so many of them, of all sizes, all varieties, all types across South Africa, doing all sorts of work and at all sorts of levels, some of them funded, some of them without funding, some of them completely voluntary. Currently, there is no registration requirement for a voluntary association for it to exist. It exists under common law. You draft a constitution, you sign it, you're up and running. Often these organizations are small community organizations. They're large in number, but they're often limited in capacity. So we're talking choirs, street associations, I mean, knitting clubs. I mean, the list, it sounds like ridiculous examples, but the way the bill is currently phrased, it would get down to that kind of level and that sort of organization. So if we have a quick look at how the NPO Directorate is currently structured and functioning, an NPO, a point we made, is not a type of organization or legal entity. It is an add-on status that any one of those 3 types of nonprofits can acquire. So the NPO Directorate is an oversight and enabling and administrative function. It's not currently a primary registration of a legal nature. So voluntary, at the moment, the NPO Directorate is undercapacitated for processing the current level of applications and administration. The NPO register itself is currently 10 years out of date, and the systems which they have are not designed to capture and to make sense of, to interrogate, to investigate the data that is needed for this. The reports which are currently lodged with the NPO Directorate, it's a tick box exercise. As long as all the pieces of paper are there, we don't think there's any interrogation of the contents. I'm just time-wise, I'm not going to read all of these out to you and just highlight that, as we've said, the NPO Directorate is not equipped Just something else to note is the master's office is still largely a paper-based system, so that needs upgrades. There are financial implications here. One of the big things that will happen is if NPO registration is made compulsory for every nonprofit in the country, even those who don't know about it, and also that the NPO Act applies even to those who haven't heard about it and haven't registered, we're going to have overreaction from the banking sector, and bank accounts will be frozen, and that will be where the nonprofits will be hardest hit from the local side. From the other side, funding. So if the bill passes unchanged, so at the moment, these, as I've said, are the types of legal entity. Trusts currently report into the Master of the High Court, the NPCs into CIPC. If the bill goes as it is at the moment, trusts and NPCs will have a double whammy of reporting, because at the moment it says all of them will have to report to the and register with the non-profit directorate. At the moment, that's not compulsory. Voluntary associations will also register, and the point of this slide is that the impact of all of this on a currently incapacitated and on the systems at the NPO directorate will result in a freezing or a failure at the NPO directorate, and that will mean every part of the sector is going to be affected negatively. So just an important point we made is that FAT doesn't just require upfront compliance and laws to be written. It also requires a test on effectiveness of those systems. So FAT is going to assess, we put these things in place, are they working? So our suggestion is we don't build something that we cannot maintain. If NPO registration is made compulsory, irrelevant excess data will hide the information that's being sought, it'll slow the system, and will have a negative impact. The directorate won't be able to keep track. It won't be possible, in fact, to be able to delve through all of that data with which it would deluge in order to identify and report on the criminal money laundering activities. The other thing is that it's a warping of the intended function and powers of the NPO directorate. If there's universal mandatory NPO registration, the non-profit sector will reject it, and South Africa will, in the long term, fail the effectiveness test. Okay, I've got 2 minutes. I've got people keeping time for me here. Just a quick glance at the provisions in the Act, and we have submitted detailed provisions. We're just highlighting some of them. Foreign organizations, at the moment, the bill makes NPO registration with the NPO directorate compulsory for foreign organizations. Section 23 of the Companies Act already covers in much better detail than the bill does how foreign companies should register as soon as they're operating, as soon as they're working in South Africa. Section 8 of the Trust Property Control Act already has a provision in place. Once again, we're saying don't bother about those, take those out of the picture because they're already dealt with. So at the moment, there would be double requirements, and the new bill doesn't says any foreign nonprofit that's operating in South Africa must register with the NPO directorate. There are some legal issues with that. There's state sovereignty issues. So our simple suggestion is that as the only group that's currently left out of being brought into the circle, unincorporated foreign associations which carry on nonprofit activities in South Africa should actually be called to register as nonprofit companies with the Companies Office, as external companies, foreign companies currently are. There's already a regime, there's already a provision and a method in place. Okay, summary of recommendations. We strongly suggest that we do not go for compulsory registration with the NPO directorate of all nonprofits, certainly not compulsory registration of all foreign organizations that operate in South Africa. There are some other points to be made, which we can't go into detail here. There's some definitions in the NPO Act. They define the board as executives, which is wrong. That needs to be fixed in order to align with the beneficial ownership definitions. Founders on charitable trusts, an ongoing report on deceased or non-existent founders is not necessary or useful. What we suggest is that conduit, in other words, on donating voluntary associations, which are those which have large sums of money flowing through them and are assessed as being at a risk, are made to register as voluntary associations as non-profit companies, under the Companies Act. Foreign voluntary associations also included inside the SIPC register. We think there's another point to be made around members who are not beneficiaries of nonprofits and disclosures of personal details of members. In the nonprofit sector, we would say that only when there's a financial benefit to members and there's a financial flow of any sort do those members need to be identified. It's hard enough to get people to volunteer and participate as it is. Just saying. Also, other legal tweaks. Sorry, I am the lawyer in the room. There's a definition of constitution in the NPO Act that needs to be amended to align it with other legislation. And I've raced through that, and I hope you've all heard me. Thank you very much. That was the Npo Working Group. Thank you for your time.
Thanks, Npo Working Group, for your submission. Let's move to freedom of religion, South Africa. Over to you, 10 minutes.
Good morning. Yes,
Please.
I will time myself. Good morning, Honourable Chairperson Mashwanyani and other members of the committee. Thank you for inviting 4SA to participate in this morning's meeting on the Anti-Money Laundering and Combating Terrorism Financing Bill. We trust that our submission will be brief, but that it will give a unique perspective to assist the committee to drafting a law that practically benefits our nation. I am Daniela Ellebeck, an attorney and the legal advisor to Freedom of Religion South Africa, or 4SA. 4SA is a legal advocacy organization, and we work to protect and promote the right to freedom of conscience, religion, thought, belief, and opinion, which throughout this presentation I'll refer to as the right to religious freedom, which is found in Section 15 of our Constitution's Bill of Rights. We have a very wide endorsement base of religious leaders spanning across different denominations, churches, and faith groups, including 10 million people from the African Indigenous and Spirituality churches. And while 4SA respects the Bill's aims to give effect to the 14 recommendations by the FAFT, we are concerned that the bill has serious ramifications for religious organizations. As my learned colleague Nicole from the Npo Working Group pointed out, this will even affect knitting clubs. So due to religious organizations such as churches, which fall within the definition of non-profit organizations for purposes of the Npo Act, mandatory registration will affect religious organizations. So before we perhaps turn to the bill itself, I just quickly want to explain what the ambit of religious freedom is. Religious freedom is a right that's protected in Section 15 of our Constitution, and it is the right to entertain the beliefs that you choose and to live them out publicly without fear of hindrance or reprisal. And it is a right that you take with you wherever you go in the public realm. It even extends to beliefs that others might find as bizarre, illogical, or irrational. It's also a right that the state is charged with protecting and promoting as it's part of the Bill of Rights. Another right that is important given the topic of this bill is the right to freedom of association, which is the freedom to choose to associate with who you want to associate with, and it includes the freedom not to associate. So you can be part of this church or this part of this knitting club or this cricket club, but you can also choose not to be part of it. And freedom of association guarantees an individual the right to choose his or her associates, and this bill also a group of individuals to choose their associates. So the right of a group to choose their associates is of necessity also the right to require those who choose to join the group to conform to the group's behavior and dictates. And it includes the right to exclude those who refuse to conform. And then also our Constitution protects the right of religious communities to practice their religion and form religious associations. So this is also a right entrenched in the Bill of Rights. And it is an example of a collectively exercised interest where members fulfill and maintain not only their basic right to religious freedom in Section 15, but also their basic right to dignity, mainly due to their acceptance of and participation in the core creeds of such a religious association. Now, it's trite law that these three rights, Section 15, 18, and 31, when read together, give religious institutions such as churches a certain degree of institutional autonomy. And this means that religious institutions have the right to decide matters of doctrine and governance internally. This is known in law as the doctrine of entanglement. The doctrine was recently confirmed by the Supreme Court of Appeal in the case of De Lange versus the presiding bishop of the Methodist Church, where the court held that associational rights are important because they not only grant individuals, but members of a particular religion, the right to exercise their religion. And the court after examining South African case law as well as foreign law, held that a proper respect for freedom of religion precludes or courts from pronouncing on matters of religious doctrine, which fall within the exclusive realm of the church. So we see that sections 15, 18, and 31 result in the well-recognized autonomy of religious organizations to determine their own doctrine and beliefs and to regulate their own internal affairs free from interference by the state. Now, turning to the concerns regarding the bill. The manner in which the bill seeks to implement the FATF's recommendations will result in, amongst other things, it being mandatory for religious organizations to register as NPOs with the DSD under penalty of imprisonment or fine. This will inadvertently override and trample on the constitutional right to freedom of religion, freedom of association, as well as the right of religious communities to collectively practice their religion and form religious associations. Turning to the specific concerns of the bill, Clause 10 proposes amending Section 12 of the Npo Act to make it mandatory for NPOs to register with the DSD. Now, religious organizations, which are either registered as trusts or as nonprofit companies or are voluntary associations, fall within the definition of NPOs of the Npo Act. And given that the Npo Act gives the DSD the power to require NPOs seeking registration to amend their constitutions by making registration mandatory, the bill gives broad and intrusive powers to the state to prescribe changes to religious organizations' founding documents on requirements, for example, membership or leadership. And such required changes will affect religious institutions' autonomy and meddle in its doctrine. Because, for example, membership of religious organizations is typically based on adherence to the organization's doctrines, beliefs, religious ethics, and so forth. And a defining characteristic of a religious organization is that they restrict membership to those who adhere to their beliefs. So from a religious freedom point of view, the bill, if it's adopted in its current form, will give the state an open door to tell religious organizations how to run their internal affairs. And this is state regulation of religion, which violates all the constitutional rights we've already discussed, as well as undercutting the doctrine of entanglement. Another concern is that of criminal sanction. And the effect of the bill's clause 14, which proposes amendments to Section 29 of the Npo Act, read of Section 30 of the Npo Act, will send pastors to jail for failing to adhere to administrative requirements. And there are serious concerns that the DSD will not have the manpower to assist churches and other religious organizations who often will not have the money to pay for legal experts to ensure that they are compliant. And as such, the DSD will not have the capacity to reach out a helping hand to religious organizations who want to comply, while at the same time making it a criminal offense for failing to comply and imposing heavy criminal sanctions such as imprisonment. And final concern is the duplication of administrative reporting duties. The unintended consequences of the bill will force religious organizations to register as NPOs with the DSD, irrespective of whether or not they're already registered with SIPC as NPCs, SARS as PBOs, or the Master's Office as Trust. This is done without consideration for the, or irrespective of the additional administrative and legal compliance burdens being imposed. And a serious concern is therefore duplication, as religious organizations will now have three groups to deal with: SARS, with various tax requirements, including but not limited to pay as you earn, UIF, etc., for any salaries that the churches may pay, SIPC or the Master's Office and the DSD. And this will unduly burden religious organizations who operate on a shoestring budget with a small contingent of staff. It's also further submitted that it's unlikely the DSD has the manpower or expertise to pick up fraud or money laundering if SARS has failed to do so. Now, given that the bill limits various constitutional rights, the state is obliged to do the limitations test set down in Section 36. No such justification has been done. And it's for a submission that given the concerns raised, if such a test was done, the bill will fail to pass constitutional muster. In the last minute I have left, just turning to 4SA's recommendations. NPO registration with the DSD should remain voluntary, as echoing what Amma Bugani and Corruption Watch and Npo Working Group have said. Keep NPO registration voluntary because you have a duplication of duties that is happening. Alternatively, if this committee does decide to make NPO registration compulsory, Section 12(3) of the Npo Act needs to be amended to specify that the DSD cannot require religious organizations' founding documents to make changes to their founding documents. that have to do with the religious organizations, doctrines, tenets, or beliefs, and that Section 30 of the Npo Act, which is the criminal sanctions, be amended to avoid threat of imprisonment. We trust you will find these submissions helpful, and yeah, thank you very much for the opportunity to present.
Thanks very much, Freedom of Religion, and also sticking to the time allocated to you. Let's move to Cause for Justice, CFJ. 10 minutes.
Thank you, Chair. Honourable Chair, committee members, please allow me to share my presentation. Can you see my screen?
Yes.
Great. Thank you for allowing us to do oral submissions at this meeting today. I'm from Cause for Justice. Just briefly, our oral submissions will focus on three broad areas. Firstly, we'll look at the importance of preventing money laundering and combating terrorism financing, the importance of ensuring adequate public participation, and we will look at three critical preliminary questions as well. Just an introduction, Cause for Justice is a non-partisan, apolitical, non-profit human rights and public interest organization, and our primary objective is advancing constitutional justice in South Africa. We are a non-profit entity that has opted not to apply for voluntary registration in terms of the Npo Act, meaning that we will be directly affected by the proposed amendments to the Npo Act. The honourable members of the committee can read more about us and our values in our written submissions, but we would just like to point out that we only intend making submissions in relation to the provisions of the Npo Act. Firstly, we would like to say, as many other presenters also emphasize, anti-money laundering legislation serves a necessary and legitimate government purpose, and it also serves the public interest. So we are supportive of the broad aims of the bill, but certain amendments are needed to the current version of the bill to ensure that it reaches its purposes and does not have detrimental consequences. It has already been alluded to the constitutional importance of ensuring public participation. We would not like to belabor the point, but we would like to point out that the comment period was very short, only 9.5 business days. And during this period, it was a school holiday break. So a lot of people, including persons working in the Npo sector, might have been on holiday either or had prior commitments. So perhaps not aware of the bill, not able to have the capacity to comment on the bill properly, enough time to consider it. There was also ongoing load shedding during office hours. And in our specific case, our drafting team sits in 3 different load shedding zones. So we need to coordinate that with sometimes very slow internet when it's load shedding to no internet, and our device batteries cannot simply, sometimes just cannot outlast the duration of the blackout. So that has had a big impact on capacity. It's already been alluded to how it is crucially important that all South Africans are given adequate opportunity to comment on this bill, and that this is a very important piece of legislation. It is important to allow an adequate opportunity because we would not want to fall foul of the constitutional obligation to facilitate effective public participation in the lawmaking process or open the bill to constitutional challenge on procedural grounds. To this effect, we would ask the committee to seriously consider to reopen or grant an extension for of the call for comments for another 30 days, or alternatively remove those parts of the bill that deals with the Npo Act. Now we are going to look at 3 broad critical questions. We did not have the time or capacity to go into the merits of specific clauses, but we will look at 3 overarching questions that are relevant to the constitutionality of the bill. The first concerns less restrictive means to achieve purpose. The question here is, are the measures in the Npo Act, which will now become compulsory, the least restrictive means to achieve the purpose of preventing money laundering and combating terrorism financing in the Npo sector? Now, as said, preventing money laundering, combating terrorism financing is a necessary and legitimate government purpose, but we must assure that the means proposed to address these public ills, in this instance, the amendments in the bill, do not go further than necessary to achieve the purpose or have unintended detrimental consequences that in the end it costs society more. We are aware of the section 36 of the Constitution, which is the limitations clause that says, yes, the rights in the Bill of Rights may be limited in terms of a law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society. And certain factors need to be taken into account. I would like to draw the committee's attention to factor E, less restrictive means to achieve the purpose. What this means is that the limitation of rights entails a delicate balancing exercise. And we should attempt to maximize respect for promoting, protecting, and fulfilling the right in the Bill of Rights. So where there are less restrictive means available to limit rights, only such means will pass constitutional muster. Now, the bill seeks to amend certain sections of the Npo Act, including making registration compulsory, requiring all Npos to comply with the existing provisions and certain new proposed provisions, or face criminal sanctions. This will now impose a legal obligation on Npos and limit the constitutional rights of Npos, the governors and office bearers, the majority of whom are unlikely to ever be involved in money laundering or financing terrorism. We would like to emphasize that this is a drastic change from the current status quo, from encouraging voluntary registration to compliance and compelling against a threat of imprisonment and fines. Moving on to a second overarching area of concern is additional compliance burden and criminal sanctions. And our question here is the burden of placing additional compliance obligations on law-abiding citizens and non-profit entities that choose to operate outside the scope of the Npo Act and the concomitant penalties and criminal justice consequences for non-compliance, a constitutionally justifiable cost of eliminating and reducing money laundering among those who conduct criminal enterprises through the non-profit sector. Additional compliance requirements means more work for NPOs, taking up more valuable capacity and resources, and it's common cause that the NPO sector is overextended and under-resourced. Many law-abiding non-profit entities choose not to apply for voluntary registration in terms of the Act for a variety of legitimate reasons. Our organization, Corso Justice, is one of these organizations. Reasons for not choosing to register include minimizing time, funds, and other resources that you spend to meet the legal and administrative compliance requirements. If the bill passes in its current format, it would force these entities to register and or comply with the Act or face criminal sanctions. And we seriously doubt whether the consequences of these measures are appropriate and proportional, in other words, constitutionally defensible when compared to the potential benefit to be achieved by them. In other words, is reducing money laundering done through criminal enterprises through the NPO sector, that cost versus the cost to the entities and the cost to society, as many NPOs would need to apply human and financial resources towards compliance. And they're already undercapacitated, under resources, instead of focusing on doing their very good public benefit work. In countries such as South Africa, where a lot of South Africans live in challenged to dire socioeconomic circumstances, the NPO sector has crucial and important work to do for the benefit of our society. If the proposed amendments will not yield a significant net benefit, they will not constitute a reasonable and justifiable limitation of the rights of law-abiding non-profit entities, their governors, and their office bearers. In other words, if the costs of the sector and society materially outweigh or exceed the benefits to be achieved by reducing or eliminating money laundering through this sector. Lastly, last overarching area of concern, likelihood of legislative amendments achieving their purpose. And here we ask, what is the level of assurance that making the Npo Act compulsory will in fact translate to preventing money laundering in the sector? It is necessary to investigate whether the proposed amendments will be effective at addressing the identified public ills, because the identified public ills are valid concerns, but will the amendments be effective? If what the bill proposes is not highly likely to translate into effectively preventing and combating money laundering and financing terrorism in practice, it would mean that these amendments serve no legitimate purpose and are an unreasonable and unjustifiable limitation of the rights of NPOs, their governors, and office bearers, meaning it places an unconstitutional burden on them. In this regard, we would request the committee to seriously investigate this issue, and to this end require the Department of Finance and or the Department of Planning, Monitoring and Evaluation to provide it with sound evidence and a rational basis for why and how the specific proposed amendments of the bill will in fact translate into effectively combating money laundering. through criminal enterprises operating in the NPO sector, and then to scrutinize and interrogate such evidence and arguments very carefully, and even seek independent expert opinions and advice to corroborate whatever evidence is provided by the government. So in summary, we emphasize the importance of ensuring adequate public participation. We looked at 3 critical preliminary questions that speak to the constitutionality of the bill. For example, less restrictive means to achieve purpose, the additional compliance burden and criminal sanctions, and the likelihood of the legislative amendment achieving their purpose. And we'd like to reiterate that we would request the committee to seriously reconsider reopening or granting a general extension for comments to allow the public to engage with the bill properly and comment on it, or alternatively remove those parts of the bill that deal with the NPO Act. Just in conclusion, these questions and others required a considered appraisal and investigation by the public in order to formulate a view and make meaningful submissions on the bill, which will ultimately help the committee also. These questions are complex. They require proper consideration on the constitutionality of intended implications and unintended consequences, and on the constitutional rights and interests at play. If we were afforded sufficient time, we would be able to engage with the applicable legal precedent, academic writing, and then would be able to provide the committee with a reasoned and authoritative answer to these questions, and to this end, augment and amplify our submissions as is necessary. But we would like to reiterate as well that we do remain at the committee's disposal to assist in the further development and or amendment of the bill for the purposes of ensuring that it effectively achieves a constitutionally compliant and legitimate government purpose, and any detrimental unintended consequences are avoided. Thank you, Honourable Mr. Chairperson.
Thanks, Lizelle, for representing a cause for justice and sticking to the time allocated. Yeah, we'll consider issues that you are raising with your colleagues. And let's move to Media Monitoring Africa, MMA. Over to you, 10 minutes.
Hello, good morning. We did not produce a PowerPoint presentation, so you'll just have to deal with us speaking, but I hope that the content will be sufficiently exciting for you. My name is William Bird. I'm the Director of Media Monitoring Africa. I'll be doing this presentation with the Senior Associate of Power Singh Incorporated, speaking to these issues. I want to just point out before I hand over to Ms. Powers to present some of the formal submissions that MMA is a member of the Npo Working Group. We fully endorse the submissions that were made just a little bit earlier. And I think from those, it's already clear that the bill in its current form is fatally flawed. And in particular, we're going to focus then the rest of most of our submissions on issues around public participation. If I can hand over to you, Tina.
Thank you, William. Good morning, Chairperson and committee members. Given the time, I will jump straight into it. MMA's concerns with the bill, in particular in relation to the NPO Act, are both procedural and substantive. It seems that there are some common views among the NPO sector today, so we don't seek to repeat any of the submissions already made by colleagues. And given the limited time we have to engage, which in our view is indicative of some of the problems with this process, we would elect to focus our submissions on the procedural concerns with this process, in particular the public participation process. And to the extent there is time, we will touch on our substantive concerns that the proposed amendments to the NPO Act may be disproportionate to the means thought to be achieved. We noted the Chairperson's introduction this morning on the importance of public participation. And while we welcome these sentiments, and with all due respect, it is MMA's view that this process has fallen far short of the constitutional standards required for meaningful and effective public participation. This has been alluded to by colleagues who have gone before us today. I'd briefly like to take the committee through the constitutional standards for public participation. Our constitutional democracy is founded on values and principles that include accountability, transparency, responsiveness, and participation. Through the public's right to participate in legislative processes, the public is entitled to be consulted and to have their voices heard. Section 59(1) of the Constitution places a duty on the National Assembly to facilitate public involvement in legislative processes of the Assembly and its committee. A duty that is not just a matter of legislative etiquette or good governmental manners, it is one of constitutional obligation. MMA is deeply concerned that the manner in which this process has unfolded has seriously undermined public participation, as this process has been neither meaningful nor effective. MMA's concerns with this process relate to the timeframes and the apparent mechanical approach adopted, as well as the implications of rushing this process. Tight timelines affect the reasonableness of a process and how meaningful a process is. Our Constitutional Court has acknowledged the practical relevance of time and expense, but has cautioned against using urgency as a justification, emphasizing, and I quote, "The timetables must be subordinate to the rights guaranteed in the Constitution and not the rights to the timetable." The Constitutional Court has further found that self-imposed urgent timelines can be inherently unreasonable. MMA submits that the timing of this process has been unreasonable. We say so for the following reasons. The FAFT report was made publicly accessible in early October 2021. Following the release of the report, National Treasury undertook to report regularly to Cabinet on the country's progress. Apart from what appears to be a few committee meetings, the minutes of which are not freely available, there is limited information as to what steps have been taken, save for media reports from July 2020, where Treasury explained that they had been working on amendments to Schedules 1, 2, and 3 of the FIC Act. Notably, MPs from the two financial committees raised concerns that they were asked to rubber stamp these amendments then and there. According to reports, the chair of the Select Committee on Finances stated that they could not receive the amendments and adopt them on the same day. Interestingly, Honourable Chair Maswangani noted, and I quote, "It would be of no use if we adopt today and tomorrow the Speaker is taken to court." At the end of August 2022, the Minister of Finance tabled the bill in Parliament. At the end of September, the bill was made public and the call was issued, with comments due yesterday, providing less than 10 working days for public comment, and now a mere 10 minutes to provide oral submissions on amendments of 5 acts tied to a process that will have far-reaching and adverse consequences for South Africa's already fragile socio-economic landscape. It therefore appears that the committee is well aware of the need for time and meaningful engagement. So it is confusing and unusual and concerning that this process is now so rushed. MMA observes the concerns previously raised by the chairperson and notes that these concerns remain. MMA further records that judicial review is not off the table. MMA's second concern relates to the meaningfulness of this process. Given the haste within which it has been conducted, the public has faced challenges in meaningfully engaging with the content of the bill, as has been explained by colleagues before us. Our courts have set out the requirements to be met when assessing the reasonableness of a participation process. The process must be objectively genuine. Unreasonable and mechanical processes may, as our courts have found, amount to a cynical charade or a box-ticking exercise. MMA therefore urges the committee to reconsider its approach to ensure meaningful participation on questions that have far-reaching consequences. As suggested by the Npo Working Group and most recently the Cause for Justice, an extension is well warranted. MMA recalls that the explanation attached to the bill notes that in order to demonstrate clearly in October 2022 that South Africa remains politically committed to the process of continuous improvement, the country should be able to report that a process to implement the necessary legislative changes is well underway. Rushing this process and limiting public participation does not prove that this process is underway. It suggests that this process may be ill-conceived and falls short of the constitutional duty to enable meaningful and effective public participation. Consultation and involvement have become a distinctive part of our national ethos. It is therefore deeply regrettable that the public has not been afforded a proper opportunity to engage on questions of such public interest and socio-economic impact. Notwithstanding these concerns, MMA notes that there are substantive concerns relating to the proposed changes in the Npo Act, namely mandatory registration. Npo's concerns relate primarily to proportionality of the proposal for mandatory registration. MMA does so for 3 reasons, and I will be brief and then hand back to Mr. Bird. MMA submits that the current response, namely the proposed mandatory registration requirement, is disproportionate for three primary reasons. First, the response is disproportionate to the identified risk. On our government's own version, the NPO sector does not currently pose a significant terrorism financing risk. Secondly, the response does not respond to the recommendations provided for by the FAFT. And third, the response may have adverse consequences on the functioning of the civil society sector. MMA urges the committee to reconsider both the procedural and substantive elements, in particular the NPO Act, as colleagues before us have mentioned. And MMA seeks to remind members of this committee and members of the public listening here today of the importance of public participation in our constitutional democracy. We appreciate the time we have been afforded, and I will now hand back to my colleague, Mr. Bird, to conclude. Thank you.
Thank you so much. Just to conclude, I think it's clear that in addition to the process itself being flawed and far too brief, the bill itself and the way it conceives of and the impact that it would have on the sector, given all the previous comments made about it, should render not only a further extension period, but that the bill in its current form, particularly in relation to the NPO Act, needs to be withdrawn entirely. We've been calling for a long time as civil society for a new white paper and a new engagement between government and civil society, and that has yet to happen. Instead, civil society was not consulted anywhere in the development of this bill, and now we're given 9.5 days to do so. It's fundamentally something that is deeply problematic, and if it continues along this tragic path, there will be constitutional consequences. Thank you very much for this opportunity. Over.
Thanks, MMA, for your presentation. We'll address the issues that you are raising. Let's move to open ownership. Over to you, open ownership, 10 minutes.
Thank you so much, Chairperson. If I may ask for permission to share my screen, that would be helpful. It currently signifies that the host has disabled participant screen sharing. Thank you so much. Good morning, Honorable Chairperson and members of the committee. My name is Karabara Julie and I'm from Open Ownership, and I'll be joined today by my colleague Timon Kip. Just to quickly put this in context, we agree, Chairperson, that this is an important bill that's before Parliament. We know that globally 70% of all grand corruption cases have been known to involve anonymously owned companies. And we also understand that there's a significant amount of resources which are laundered, which are facilitated by not knowing who ultimately owns and controls companies. Globally, as well as in South Africa, we know that the risk around this is because information is either missing or it's inaccessible or it is hard to use. And this ultimately makes ownership information opaque. South Africa, along with many other countries, has made commitments to beneficial ownership transparency or knowing who owns and controls companies as well as trusts. We've seen a rapid uptick of this particular policy as well as legislative process in response to some of the cases of corruption, but also in response to countries wanting to really either increase participation within the economy or really identify other policy goals around competition within the marketplace and so forth. So this has really become a crucial policy as well as implementation area. But it is a very complex area. Open Ownership is a global organization that focuses specifically on beneficial ownership implementation. Through doing a number of things, we offer technical assistance to countries with their implementation processes, as well as really providing the evidence base for this work through policy and research, many of these tools which we'll be sharing as part of our presentation. And then finally, and we'll talk to this in the presentation, legislation. We support something called the Beneficial Ownership Data Standard, which is really to assist with the usability of beneficial ownership data to really identify its policy goals. In terms of our approach to the review of the General Laws Amendment Bill, we focused on aspects of the bill which we have particular expertise, and so we focused on 4 pieces of legislation. We have not provided comments on the non-profit organization sections of the bill because these have limited relevance to beneficial ownership and open ownership's expertise. This presentation will touch on specific areas which are more detailed in our submission, but in the interest of time, we won't go into everything that's currently in our written submission. I will hand over to my colleague Timon to talk through the first parts of our responses to the piece of legislation, and then I'll come in to talk to other aspects of the bill. Over to you, Timon.
Thank you, Karabo, and good morning, Chairperson, committee members. Can you go to the next slide, please, Karabo? We've reviewed the bill with respect to our own framework for how we define effective disclosure, and we define effective disclosure as producing data that is useful and usable to achieve specific policy and business goals of users. Obviously, a key one for South Africa is combating money laundering and corruption. Next slide, please. So we have 9 aspects that we look at, and we're going to focus on 5 very quickly today in this presentation. So that is how beneficial ownership is defined in law, the scope or the coverage that it applies to, access to the data, how data is collected and structured, and sanctions and enforcement for non-compliance. Next slide, please. So a key challenge in defining beneficial ownership in law is that beneficial ownership is a substantive concept, and when we're talking about beneficial ownership, we're talking about who de facto controls a corporate vehicle, and translating this into law reduces it to something that's quite narrow in scope and formal, which is a challenge that many countries face. So the way that individuals can directly and indirectly control businesses depends on specific legal context in a country. Next slide, please. We always like to talk about this case. This is the former Czech Prime Minister who's been found guilty of having several conflicts of interest while owning companies that received EU funds. The company in question was liable to disclose in 2 different jurisdictions and only disclosed his ownership in one, Slovakia, that had a very strong definition and was not liable to be disclosed in the Czech Republic, which had a very weak definition at the time, which was subsequently amended this year because the EU found it to be insufficient and incompatible with EU standards. So based on this type of analysis, we've identified what makes a strong definition. Next slide, please. Very specifically with respect to the bill, so it's very welcome to see that there's a unified definition in the law that other piece of legislation refers to and expand on. However, we do think that the definition lacks specific aspects that we would preferably and ordinarily see in primary legislation, such as thresholds, which you can see on the slide. We've done some analysis and mapping the visibility of beneficial owners based on a set threshold. And this was using data from Nigeria, where you can see that at a threshold of 25%, you already miss visibility of over half the beneficial owners that you might potentially be interested in. Furthermore, the definition in the bill does not include a list of how beneficial ownership and control can be held. We further would expect and hope to see an explicit prohibition of what cannot be disclosed as beneficial owners, such as nominees. And we'd also like to point out that the proper regulation of nominees is a new and explicit requirement in FATF's recommendation 24 and is currently insufficiently covered by the bill. Furthermore, the the definition in the FIC Act is currently framed fully in terms of know your customer and customer due diligence procedures for accountable institutions, referring to additional guidance note produced by the FIC. We think that this can be simplified and be made less convoluted to have a simple and more generally applicable definition of a beneficial owner. Furthermore, we've identified some gaps that remain in the additional definitions, such as in trust, where some key parties of trust are not covered. Next slide, please. Next slide, please, Karabo. I don't know if, there we go. So the coverage, so we would expect that the legislation should comprehensively cover all legal entities and arrangements for which a money laundering list exists. We'd like to highlight this with the example of Scottish limited partnerships in the UK, which were known as the getaway vehicle for corrupt individuals and organized criminal gangs. As you can see in the graph, essentially in around 2015-16, when the beneficial ownership disclosure regime was implemented, which initially did not include Scottish limited partnerships, the registration spiked when this was brought to the attention of the authorities, as well as their use in money laundering cases. They were brought within the scope of disclosure in 2017, after which their registration dropped, which shows to us that all entities and a legal arrangement that pose risk need to be comprehensively covered and can provide a deterrent effect to their abuse. And with respect to the bill in question, the bill does comprehensively cover companies, but we have some questions around the way that trusts are covered, and specifically foreign trusts, where trustees are residing in South Africa or assets are held in South Africa. They're currently not sufficiently covered by the bill. In addition, we would recommend that some special attention is paid to some entities which might struggle with the disclosure requirements and which currently provide similar and adequate information to the government via different channels. So particularly, the bill may wish to include exemptions for listed companies listed on exchanges with sufficient transparency requirements. These are currently not included, which leads to a huge compliance challenge for listed companies. Next slide, please.
Timon, I'm not sure what you can see right now.
It's I still see listed companies. And I'd like to hand it over to Karabo for public access.
Right, thank you so much, Timon. There might be a bit of a lag on my side, so just to indicate that on my end. A number of colleagues this morning have covered issues related to including provisions in the bill which create certainty around who may or may not have access to beneficial ownership data held by the different registries. Currently, the wording in the bill just indicates prescribed persons will have access. But one area which we want to really emphasize, which hasn't been covered, is more accessibility broadly to competent as well as law enforcement, which has been a key recommendation coming out of the October FATF mutual evaluation. One of the key things that the evaluation looked at and was that law enforcement as well as competent authorities should have timely as well as direct access to information held by a BO register held by a public authority. Now, whilst the prescribed persons indicator, which will be specified in secondary legislation, could be the place in which to determine how access will be provided. And given the importance of this and given the importance of having both legislative as well as regulatory certainty, we would recommend that in addition to some of the comments and recommendations that colleagues earlier have said around being quite clear that the register will be made publicly accessible. In our full submission, we talk about the benefits of having a public register. We would also recommend that it would be important to, in the primary legislation, be quite clear that law enforcement and competent authority will be able to have both timely and direct access, really creating certainty around how this access will be provided, but also making sure that the recommendations coming out of the October evaluation are seriously indicated in legislation. That's the first area. And then also just to flag that one of the recommendations coming out of the revised FATF recommendation 24 is access for not just competent and law enforcement, but also to broader public authorities, which may include procurement authorities. And so we would recommend that in order to make sure that by the time this legislation is passed, it doesn't quickly become outdated, meaning that the Parliament must go through another process in a year or two to update this legislation. It would be prudent for the legislation right now to really consider the already revised recommendations around FATF requirements. Just quickly on public access, colleagues this morning have touched on sort of the South African constitutional provisions. We do see in a number of other jurisdictions who have made decisions to have public data or bio data published publicly. They have really considered some of these provisions around how can public data be balanced with data protection more specifically. And so a number of jurisdictions, both in the region, so for example, Nigeria, Botswana has recently amended their legislation to now have a public register from previously having a closed one. Indonesia has done the same to open up their previously closed data. We do see that globally there is a lot of emerging best practice on what this will look like. We do, of course, understand that there might be concerns around ensuring that personal data, because beneficial ownership data does have personal information which is contained in it. We have created guidance based on some of these emerging best practices on what publishing data publicly may look like. And there's a couple of points which could be considered, and this will probably be specified in secondary legislation. The first is to have some type of provisions around data minimization, simply meaning that any data which is not actually useful for collection is not collected. The second is about having layered access. So for example, law enforcement, competent authorities, other public authorities such as procurement authorities might have full and unfettered access to all of the data for purposes of investigations, but the public will have sufficiently meaningful data made publicly available. And lastly, in instances where there is a legitimate risk to a person who is a beneficial owner, there's examples globally around, for example, victims of gender-based violence who have made requests around not having their data released as it might legitimately harm them. So there are ways in which to make the data public while still upholding or managing the risks around it. A key point that we wanted to raise, and I think yes, Chairperson.
How many slides are you left with? Because you have gone beyond the located.
Thank you, Chairperson, for keeping the time. We're about to wrap up, but I just want to zero on these last 2 points. Because of the approach that South Africa is taking in terms of having multiple registers, we think it would be beneficial to have some kind of data standard which will ensure that the registers can be connected to each other, but also quite importantly, because of the nature of beneficial ownership data, which is often multi-jurisdictional, having a data standard which is used by other countries will ensure that if law enforcement or other users of data want to link data sets across jurisdictions, this will be possible. And so in terms of our guidance or what we see in terms of best practice, we do see countries beginning to think about legislating not just for a standardized definition, but also for a standard beneficial ownership data standard within legislation. And this will really ensure that the data is usable. I'll briefly hand over to Timon to wrap up looking at sanctions and enforcement, and then Chairperson, I'll hand the room back to you.
I'm going to keep this very brief in the interest of time, but we wanted to focus on sanction enforcement because this was something that the FATF mutual evaluation had picked up as being currently inadequate. In the review of the new bill, the sanctions are fairly comprehensive, but we have still identified some weaknesses. And I think just to wrap up with some general points is that from our experience globally, it's difficult but possible to legislate for comprehensive beneficial ownership transparency reforms with a view to generating useful and actionable data. This takes time, and there's not a huge amount of time that has been given, as has been pointed out by colleagues. I think South Africa is doing this at a good time when there's a new recommendation 24, when changes are being made to recommendation 25. So I think it's well worth taking the time now to ensure to get this right, as my colleague Carlo mentioned, to ensure that you're not chasing the facts and having to re-legislate in 2 years' time. Thank you very much.
Thank you so much, Chairperson.
Okay, thanks, Open Ownership, for your submission. Let's move to JSE. 10 minutes allocated.
Thank you very much. Thank you very much, Chair. I would, I see the presentation's up. Thank you. My name is Leila Fourie. I'm the CEO of the JSE, and I'll introduce our presentation, and then I'll hand over to the JSE team. Joining me today is Andre Visser, Director of Issuer Regulation, Louis Cochrane, Legal Counsel, and Anne Clayton, who is Head of Public Policy. Our Director of Market Regulation may be joining the hearings a little bit later. The JSE is ranked 19th largest stock exchange in the world by market capitalization and is a leading exchange on the African continent. The JSE is very much at the center of the South African capital markets, and we connect global investors through our platform, which delivers very secure and efficient primary, which is listing, and secondary, which is trading capital markets, and access across a diverse range of securities, which are supported by our post-trade services, so for clearing and settlement, and underpinned by our regulatory functions. This makes the JSE the market of choice for investors who are looking to gain exposure to South Africa, and for local and international companies that want to raise capital. Moving on now to the second slide, the JSE recognizes the importance of, and we are very supportive of, South Africa's role in the global effort to address anti-money laundering and the financing of terrorism. And we recognize the urgency to implement the measures to demonstrate progress towards increasing the effectiveness ratings of immediate outcomes, and also to improve the technical compliance within the Financial Action Task Force recommendations. The JSE has engaged in constructive discussions with a number of governmental departments who are responsible for this bill, and we are committed to try and to continuing to work with these departments to ensure an optimal outcome. The JSE hosted a workshop recently for companies listed on the JSE to discuss the proposed amendments to the Companies Act, and the 34 companies that attended the workshop expressed their broad support for the JSE's position and the recommendations set out in our submission. I'm going to hand now Chair to Anne Clayton, who is our Head of Public Policy, to take us through the detail. Thank you very much for your time.
Thank you, Leila. Good morning, Honourable Chair and members of the committee. I can't really see, but I think my screen is sharing. So please will you confirm that you can see my slides? Oh, thank you. Thank you very much. I will try to summarize our submission. We did do a very detailed submission. I will just try go through this very quickly in the time allocated, but I may not be able to get to the nub of some of these issues just given the time constraints. So the bill has not been subjected to a public consultation period. in advance for the call for public comments by the Standing Committee on Finance. So we had a very short period in which to formulate our submission. We are committed to find a pragmatic solution to some of the key challenges of the bill, and that solution should ensure that the perhaps unforeseen and unintended consequences of the proposed amendments do not result in undue and impossible burdens being placed on companies listed on the South African exchange. In the limited time available to us, we have focused our attention on the proposed amendments to the Companies Act, particularly with the potential impact on listed companies in mind. So we do support, in fact, we fully support the introduction of a central beneficial owner register of companies that will be maintained by SIPC. However, the proposed amendments to the Companies Act are unworkable for public listed companies. The vast majority of the companies listed on a South African exchange will not be able to comply with the proposed beneficial owner disclosure and reporting requirements. We have found that increasing regulatory burdens on publicly listed companies has contributed to the number of delistings on the JSE. For example, the number of JSE listed companies has declined from 529 in January 2002 to 311 in July 2022. Onerous burdens on listed companies disincentivize companies from raising capital on an exchange or remaining listed, which consequently has a negative outcome for the growth, vibrancy, transparency, and global attractiveness of the South African markets. The proposed amendments are not aligned to the transparency and disclosure practices in developed markets in relation to public listed companies, and if implemented, could encourage companies from raising capital on a South African exchange. In our submission, we unpack the international approach, and particularly we have provided some detail on the US market, the UK market, and the EU. And we have found that many companies have implemented a beneficial owner registry and reporting requirements applicable to all registered or licensed companies, but they provide for exemption from reporting to the beneficial owner register for public listed companies where other mechanisms provide adequate transparency of ownership information. Those other mechanisms are aligned to the existing requirements and practices in South Africa, aligned to what we already have in our Companies Act. Implementation and that approach recognizes that it's unrealistic and ineffective to require that listed companies obtain, maintain, and disclose beneficial ownership information of their shareholders, as listed companies have significantly more shareholders than non-listed companies, and share ownership of listed companies changes on a more frequent basis. Implementation of the amendments as they are could lead to listed companies moving their primary listing from South Africa to a jurisdiction with sensible, practical, and effective disclosure requirements. This, of course, will have a negative outcome for the growth, vibrancy, and transparency of the attractiveness of the South African markets. We also have provided in our submission a detail of how the current securities register is structured. So the current security register of shareholders is fragmented the majority of the registered holders that are sitting on the share register are nominees who act as the registered holder of securities on behalf of underlying beneficial interest holders. These nominees are typically operated by banks, brokers, and investment managers acting on behalf of their clients. I think it is important that we understand what a beneficial interest holder is, and it is natural or juristic person who enjoys the ultimate rights of ownership of the relevant security registered in the name of the nominee. Importantly, it's different to a beneficial owner or ultimate beneficial owner in the context of the FATF recommendations or the FIC Act, which means specifically the natural person who ultimately owns or exercises ultimate effective control over a juristic person. The vast number and geographic spread of direct and indirect owners of shares in a listed company and the frequency at which the shareholding on a listed company changes and the structure of the shareholder register of a listed company are important and practical considerations and factors that preclude a listed company from being able to collect and report accurate and complete beneficial ownership information. Just highlighting the difference between what beneficial ownership is, beneficial interest, and legal ownership and control. So beneficial owner, as we've discussed earlier, essentially of a company, essentially is a natural person who actually owns the company or who really exerts effective control over the company. But that natural person may not, and often is not, in a position of legal ownership and control. Beneficial interest essentially refers to those persons, either natural or juristic, who participate in any of the distributions in relation to the company's securities, exercise rights attaching to the company's securities, or can direct the disposition of the company's securities. These are the holders of the bundle of rights attaching to the securities of a company. And the beneficial interest holder enjoys the economic benefits attaching to the company's securities in those instances where the relevant securities are registered in the name of another person, and typically a nominee. Legal ownership and control refers to the person, natural or juristic, who is able to exercise the majority of the voting rights associated with the securities of a company. So in practice, that's 50% plus 1. Voting rights gives you legal ownership and control, and it's not limited to a natural person. It may be a natural or juristic person. Moving on, we have made a number of recommendations to the proposed amendments to the bill. We've proposed refinement to the definition of beneficial owner to provide some clarity in the practical application of the definition. Specifically, we have advocated or recommended the removal of the reference through to the FIC Act because it's simply not fit for purpose for the Companies Act because it's referring to client. So we've made some refinement to that definition, and we also, within our recommendations, provided for correct and appropriate distinction between the concepts of legal ownership and beneficial ownership of a company. We also provided a recommendation, which is a provision to empower the minister in consultation with the Minister of Finance and the Financial Intelligence Center to exempt certain companies, including listed companies, from the requirement to file a record of the natural persons who ultimately own or control the company and any changes thereto. We have also proposed that we would make amendments to our listings requirements to provide more transparency and accessibility to law enforcement and competent authorities regarding the holders of significant beneficial interest in a listed company. And lastly, we provided a recommendation on the replacement of the provision that requires a company to record beneficial ownership information in its securities register with a provision that requires the establishment and maintenance of a separate register of beneficial owner, given that the securities register is not an appropriate register to hold beneficial ownership information. Thank you. I have got to the end of my presentation. We just want to note that we are fully supportive of the government departments and committed to working with them to ensure that we get an optimal solution for our country in a manner that supports a competitive and efficient capital markets. Thank you.
Thanks, JSE, for your submission. Alan, I hope all the stakeholders have made their submissions so that I can move to item 3. Haven't we left any stakeholder?
No, Chair, that was all that was on the program to present.
Okay. Colleagues, let's move to item 3. Interaction by the committee. Colleagues, members of the committee, are there inputs that you would like to make? Probably let me allow Advocate Jenkins, are you still there?
Chair, I'm here, Chair. I'm here.
Can you come in on the issue that is raised by stakeholders that they're raising a serious issue that we have allocated them very little time for them to make qualitative submissions. So they would like that we extend the time allocated for submissions. How do we accommodate their concern?
Chairperson, I think the first point is that the public participation process, of course, can be a make or break issue for a bill. So we take it serious in any case, in any event, since the Constitutional Court gave clarity on exactly what is meant with the provisions in the Constitution and how it relates to Parliament's obligations. So we have in any case of asked the executive in terms of our rules to always indicate what consultation they have done in preparation of the bill that they introduce. That is in the memorandum of the bill. When we then deal with public consultation, Chairperson, and as we see today, we have various stakeholders indicating that they did not have sufficient time either to then present a detailed legal opinion on their view of constitutionality of the bill, or for any other matter. We allow, Chair, and this can be done by the committee, and I'm saying this to you as that can be allowed, to say to the stakeholders that, of course, they are welcome to submit further written submissions to the committee. And the committee can decide at a later stage whether they want to open the public hearing again and have an oral presentation or something like that. Nothing prevents someone from requesting it, but to accommodate those people who felt that there was not sufficient time to make a detailed submission, the committee may decide to allow further written submissions, further legal arguments that National Treasury can respond to, or any of the other government departments, and then the committee will deal with the two views and finalize the bill. So that can happen, Chair. It doesn't have to stall the process as such. Thank you, Chair. And that can go on, Chair, until the committee decides on the bill, until we do the clause by clause or something like that, or at least till we do the conceptual view of what the bill is trying to achieve. So, Chair, that process can stay open till the committee wants to close that, and that's my suggestion. Thank you, Chair.
Okay, thanks for that clarity, Advocate Jenkins. Committee members, I see Honorable de Villiers, over to you.
Good morning, Chair, and good morning, stakeholders and fellow colleagues, honorable members. It is, to make a long story short, it is very clear to me that the vast majority of the stakeholders felt that the public participation process was not reasonable. We do have a constitutional democracy. Participation is one of the fundamental concepts of what we as Parliament need to do in our oversight. I would like to suggest that the public participation process be extended, and maybe a practical extension would be, it seems like there's been about 10 days of public participation that was granted. I would suggest that it be extended by at least another 20 days to come to overall 30 days period in which stakeholders had an opportunity to reasonably go through the bill and submit submissions. It is quite clear that the bill has a lot of unforeseen or unplanned consequences, and that this needs to be interrogated, and that it's in the interest of South Africa and of avoiding grey listing that we do not rush a bill that needs to be effective and not have practical implications in it, which will just render it ineffective. It seems like there's a lot of suggested legislative processes, especially the registration of organizations that would really that some of the stakeholders feel would really not add or strengthen the government's efforts in doing anti-money laundering and anti-terrorism, but would frustrate the NGO or the NPO or the voluntary associations sector tremendously and have a massive detrimental effect to the most vulnerable of society, who are very, very dependent on these organizations to support them. So it would absolutely be my submission that we must extend the public participation process. My suggestion is another 20 days, but I'm happy to hear suggestions from the other members. Thank you, Chairperson.
Thanks, Honorable de Villiers, for your input. I see in the platform there's Honorable Abraham, Mhlonishwa Kosane, Honorable Swart. Is it the predicant, the pastor?
Morning, Joe. It is the pastor.
Who can that, my pastor?
It's good to see you. It's good to see you.
I will come to you. Honorable Abraham. No,
okay, I'm sorry. I was struggling with muting. I'm so sorry, Chair. Yes, I'm Chair. And yes, I was also going to start there in terms of the processes that have been followed. And partly in agreement with the honorable member that just spoke, I just want to hear first from National Treasury what the discussions have been, what the processes have been, and maybe Chair, just to find out also what is at stake in terms of time, because we might, we do have different options, for example, whereby even when we extend times, we have different ways of ensuring public participation. We just need to know how we are going to be injuring the processes. I know that the advocate has given us a green light as to what can be done, but I would also like a chair for us, after the members have commented, to give over to Treasury so that they speak on the issue of process first and foremost, even before they respond to any other thing that the stakeholders have raised. That would have been my take on the issue, Chair. Thank you very much.
Enkosi. Mhlonishwa Skhosana.
Sithokoze sihlalo silotshisa wonke amalunga akhona nama-stakeholders akhona and the National Treasury. Yeah, Chair, I think as I was listening, the overwhelming majority, I think, of stakeholders who made presentation, I think they are all complaining about one thing, the issue of time, that they were not given sufficient time. And also, but I'm taking note of the fact that there are also timelines and other pressures, like Honorable Abrahams, she's indicating. But also, I think for us to proceed without giving them that kind of an extension, I think it will be seriously unfair, because I think it looks like they were unable to present a different legal argument based on the fact that they did not have enough time to do that. But from the word go, they are able to indicate that on the aspect particularly that relates to NPOs, I think they have reservations. But then if they can be given more time, they will be able to present much more detailed legal arguments in relation to that. But I agree also with Honorable Abrahams that let's hear the National Treasury in terms of the pressures of time and what. But I'm strongly of the view that extension need to be granted as proposed by Honorable de Villiers, because I think it will be unfair for us just to proceed without having had all legal arguments in relation to the aspects that they've highlighted as they were presenting, because the overwhelming majority of them, I think they are all complaining about the issue of time. Thank you very much, Chair.
Siyathokoza Mhlonishwa. Pastor Steve, over to you.
Thank you, Chair. I support my colleagues on the committee in the fact about additional time being given, given the legitimate concerns expressed by many of the members, that the civil society members that made their submissions. I think these are far-reaching implications, particularly for the NPO sector, very far-reaching, including the religious sector, and unintended consequences for your knitting clubs, your soccer clubs, your choirs. And we can definitely, I agree with the honourable members that one can't proceed with dealing with the bill until the submissions are received. In my view, it doesn't matter what National Treasury says. We have got a constitutional obligation to allow for proper public hearings and public submissions. And there could be another reason why this bill has been brought to us so late. That's a separate issue. But one can't proceed with dealing with the bill until those submissions are received. And I'd be in agreement that 20 days should be allowed. And one really needs to reconsider the whole issue of the NPOs. I'd be interested from the state law advisors as to how this bill was certified, given the constitutional arguments that have been raised, particularly on the NPO sector. I think they are compelling, and it will be very difficult to support such a bill given those constitutional arguments. Thank you, Chairperson.
Baie dankie, Pastor. Okay. Oh, Akbar Vessels. Over to you.
Thank you. Thank you so much, Chairperson, and good morning. Apologies for not switching on my video due to bad connectivity. Chairperson, I just want to echo the sentiments of the colleagues with regards to additional time and extending the time for public participation. I think it would be in the best interest of the constitutionality of this amendment bill. I think there's serious consequences, and I don't think we should risk having this bill challenged later due to a lack of public participation on the one hand. On the other hand, we should afford organizations and stakeholders efficient time to sufficiently comment on this important amendments, especially with regards to the NPO sector. Thank you, Chair.
Thanks, Akbar Vessels. Treasurer, who's here from Treasury to respond in the main on the issue of public participation vis-a-vis the pressure that you have for the bill to be passed to comply with the FATF regulations. So we have to strike a balance between our international obligations and the consequences if the bill is passed in its current nature to NPOs, business, and other stakeholders in South Africa. So we have to balance national interest as compared to regulations that are set by international regulatory bodies. So over to you, Treasurer, then we'll decide as to how we proceed with this process. Who's leading the team from Treasury here in this platform?
Afternoon, good morning, Chair. We have actually quite a big team with us from Treasury, including some colleagues from the FIC. Chair, thank you for the opportunity to just initially respond. I am going to, deal with the issues in sort of two aspects. I would perhaps start with just outlining the timelines and the consequences of those timelines with respect to, I think, our collective aim of avoiding a grey listing, which requires passage of the technical compliance aspects contained in this bill, but not only in this bill, in other committees being dealt with in Parliament, which will all be on track to be completed to allow us to avoid the grey listing. May I call just initially on the FIC? I think Peter Smith is on the line from the FIC, who will just outline the various milestones that we're aiming to achieve, and the role that this law has in achieving those milestones with the view to avoiding a grey listing, if that's okay. Peter, I don't know whether you are audible and you can hear me on the.
Yes, thank you very much, Michele. Good morning, Mr. Chair, and honourable members and members from the organisations that have commented this morning. I just want to preface the explanation of the FATF process by saying that we're not saying, by explaining this, that the committee is under any undue pressure to circumvent or shortcut any processes that are required for the committee to deliver on its own mandate and responsibilities. But this is simply additional information for members to factor into the decisions that they need to make. The FATF expect South Africa to present a first report on the steps that we are taking to address the findings of the MICH valuation that was completed last year by November this year. In other words, in November this year, we will be sending the FATF a report of everything that we've been busy with in more than a year now. And the steps that we are taking in relation to each of the findings that were made in that MICH valuation report. And that material will be referred to a panel of reviewers that will be drawn from various FATF member countries, and the work will be divided among these reviewers to analyze the material that South Africa will have presented, and to form a view of whether we have taken sufficient steps to address the findings, or whether we are working in the direction of addressing the findings, but we're not there yet. We will be meeting with the committee of these reviewers in a face-to-face meeting in January next year, and we will be answering their questions. There will have been a lot of information going backwards and forwards, explanations and further clarifications given during the period of November, December, and leading up to the meeting in January. And in January, we will then be formally discussing with the review team what their conclusions are, whether there's still scope for us to provide additional information that may change their views, or additional explanation and clarification of things that we may believe they may not fully understood. The report from that meeting in January from that committee will then serve at an FATF meeting in February next year. And based on the content and the recommendations from this panel of reviewers in that meeting in February, the FATF membership will then make a decision whether South Africa has done enough to address the findings, at least the material aspect of the findings from the MICH evaluation report, and therefore that a grey listing would not be justified. In such a case, they will continue monitoring South Africa, and South Africa will continue its work and reporting on an annual basis to the FATF on further progress, but without the additional pressure of a grey listing. However, if the FATF in the February meeting is of the view that South Africa has not addressed the material aspects of the findings in their report yet, the FATF will then decide to greylist South Africa and will then formally set a task for South Africa to address the specific findings within a specific time frame and report according to that action plan and in that time frame on a regular basis to the FATF while South Africa then remains greylisted. And we will then remain greylisted until such time as we have convinced the FATF that we have addressed those specific action items that the FATF will have presented to us in an action plan and within those timelines. And that can be anything from a year up to 2-3 years, depending on the nature of the actions, what needs to be done, and at what point we are able to convince the FATF that we've addressed those findings. So that is the FATF process. The FATF principles are that they do not consider work that is in progress as having achieved an outcome yet. So things like legislation, for instance, will only be considered to have achieved an outcome if the legislation is in force and actually applied in practice. And that is a general rule that the FATF applies in all assessment work that it does. So if we are in a stage where our legislation is still in progress, in other words, for example, still under consideration in Parliament, the FATF will then say, in that case, we take note of your process, but we will then greylist South Africa and follow the process, and that will become one of the action steps that we would then have to report on, is the completion of the legislation and the enactment thereof. That's just by way of an example of how the FATF would deal with such a scenario. Because the FATF monitors a large number of countries, not just its own members, but other countries in the same process as well, and they treat all countries that are being monitored in this process consistently and equally, they do not consider requests for extensions or additional time from any country in this process. And one can understand that in a process such as this, if there seems to be preferential treatment for some countries in the process and not others, it will discredit the FATF's process entirely. There's no scope for asking for additional time or extensions in the decision-making points along the road in this process for the FATF. So that's just the background information on the process and the contribution that this bill will make to South Africa's process of reporting. This is certainly not the only step that South Africa has to take. It's addressing the findings that require legislative amendment. There's also other requirements for South Africa to demonstrate results in other areas. But without addressing the legal amendments that are necessary, South Africa will be it will be impossible for us to argue for the FATF that we've done enough to justify not being grey listed, in spite of anything else that we might have achieved by then. Thank you, Bukele. I'll hand back to you.
Thank you so much, Peter. So Chair, that just gives a sense of the process and timelines. I mean, we would also just to underscore some of what Peter said in terms of the real impact, the real person consequences of grey listed. When we spend some time in our introductory presentation on the massive effect that this has and the disproportional effect of a grey listing on the most vulnerable who rely on financial services that where a lot of these additional frictions will be disproportionately placed on them. So we certainly take note of that, Chair, and we would also take note of the really helpful presentations that have been made by the submitters today, and would really maybe like to indicate that we take on board the useful and constructive comments, as well as, I guess, one that was just recently posted on the chat that, and we're encouraged by it, that there may be a way forward to reconcile some of the issues that have been outlined in the presentations today in a way that does not massively or imply massive delays, and that it's possible, I think, for us to meet each other on these issues. Some of them, I think, maybe require some explanation on some of the intention of the clauses, and maybe explaining some of the context a little bit better, but as well as maybe taking on board some of the specific suggestions and the really helpful suggestions that were made in some of the presentations. So we again, I think, like to thank the submitters for their issues and express a willingness to try and reconcile some of their concerns, as well as some of the constitutional concerns, which we don't think are insurmountable. We certainly think that there is a path and a middle ground that we can navigate to reach an outcome that would meet that would address the concerns, the proportionality of the clauses that have been outlined, as well as achieving what is in, I think, a common interest of making sure that the financial system is not used to facilitate the financing of terrorism, as well as money laundering. Chair, let me stop there and hand back to you.
No, okay. No, thanks, Vukile and Peter. Yeah, members are recommending that we should extend the time allocated for public submissions, and there is already a proposal that another 20 days or so. So we wanted to hear from you as to whether that will negatively impact on this process. But it should also be made clear that this bill was tabled in Parliament just recently, whereas Treasurer was seized with this matter from 2017. So it must come out very clear from the side of Parliament that it's not Parliament that is unnecessarily delaying the process of passing the bill. The executive should take the responsibility for tabling the bill very late when they were supposed to go back and report to FATF. I think this point should be recorded so that when we leave this meeting, there should be no impression that it is Parliament that is unnecessarily prolonging the process. We just received the bill quite very late and we're doing everything we can to try to comply. Parliament is an arm of government that has been voted by the people. And if the people who are here in the platform, they give us time, we will be unreasonable if we don't listen to them. So where else are we drawing or deriving our mandate if not from the people who have voted us? So it will be like a mockery of democracy and public participation. So we'll have to strike a balance to try to make sure that we assist Treasury to comply with the regulations. However, stakeholders are also raising very serious issues that have to be considered. I see Honorable Swart is raising his hand again. Follow up, Honorable Swart, over to you.
No, Chair, I wanted to just endorse what you've said. We sit with this perennial problem with the executive when it comes to constitutional court deadlines and bills, and now we're sitting with this issue relating to National Treasury. As you indicated, sitting from 2017, and yes, one wants to try to assist Treasury to comply with regulations, but there must be an explanation from Treasury why they've taken so long. We also need an explanation. There's a whole separate issue about prosecutions from the justice side, why they've taken so long. So my challenge is, if you look at the timetable that a report has to be given in November, how can this bill be finalized given the massive and wide impact that it has, particularly on the Npos, on the religious sector, by this month? Then it's got to go to the NCOP. They have to have hearings. The president has to consider it. There will be petitions if it goes through in the present form. There will be petitions to the president. It is highly unlikely that it will be finalized by November. Yes, we understand from Treasury, Mr. Smith, that there will be additions to the report that can be ongoing to say that the process is ongoing with this particular bill. But I would suggest, Chair, that we give an extension. But firstly, the Treasury, and it seems that Mr. Davidson is taken to heart the concerns of the NPO sector. If we can have a quick fix to the NPO sector, considering the challenges there, considering the challenges with the Department of Social Development, considering the other registrations that already take place with CIPRO, with SARS, we can have a quick fix there. You're going to remove a lot of the challenges to this bill, and it could be finalized quickly. If we're not going to meet the NPO challenges, then it's going to be an extended process. So I think, Chair, there is scope to shorten this process if Treasury can come back quickly with solutions. It might not be necessary because the NPO sector are going to just repeat largely what they've said already. Come back quickly with solutions and we can try to assist you. Thank you so much.
Thanks, Honorable Swart. Alan and Advocate Jenkins, if we extend the time for public participation, what impact will it have on processing this bill and ultimately take it to the NA for a decision and later to NCOP in terms of time frames?
Chair, and then sorry, just to it's obviously up to the committee to
decide on an extension and the length of the extension. But just to highlight that the MTBPS process is coming up as well as the BRRR process, but that doesn't stop the committee from utilizing other days, like sitting on a Thursday after caucus, or sitting on a Friday, or even after plenaries in the afternoon. We've done it before, so that shouldn't be a challenge, at least from my side, or from an administrative point of view. Also, just to highlight that any meeting over and above what's already been approved on the committee program obviously need to apply to the House Chair for that. But again, that is not an issue. It's just a matter of putting in an application, and considering the seriousness of this, I do not think it will be denied or declined. Thank you.
Thanks, Alan. Advocate Jenkins, are you there?
Yes, Chairperson. As I said before, the suggestion that I have to allow an extended time frame for public participation is in fact not really extraordinary. It's allowed in many committees where after the date, today being that date, on which we would like as a committee to have PowerPoint presentations, or to hear the civil society, or to hear any person, media, etc., on a bill. That is a date where we get our presentation, to allow the continuous public engagement on this matter. Shouldn't keep the bill up unless we have really programmed that we want to look at the bill in a very short space of time. I don't know the exact program, your Chair, but I think what one can do is to say that it's of course a matter of urgency for everyone at the moment, for the executive to try and comply with the FATF and to prevent the grey listing, and for Parliament to attempt to finalize this bill by the end of the year. So in my suggestion is, if we give stakeholders a certain amount of time while continuing with the bill, so we get those submissions as soon as they're ready. Of course, stakeholders need to realize the sooner they make that submission, the sooner or the more time the committee will have to consider it and to deal with it while we're looking at the bill. So we don't have to wait until all the submissions come in. We can continue and actually engage with public if the committee wishes so, to engage the public on a certain matter of the bill. For instance, the NPO issue has come out very strongly this morning. So if the committee is feeling a little bit insecure about that, for lack of a better word, Chair, nothing prevents the committee to say on a Thursday, we give 2 hours just to look at this NPA matter and to the non-profit NPO matter, and to see what exactly is the problem with the definition as it is, what kind of burden will it put on various small non-profits, and what is the real reason why we're also targeting non-profits other than FATF that have indicated that. I know it's a huge issue in the United Kingdom. Unregistered non-profits is actually on the increase since they were not in the initial definition, and now the Treasury is trying to do something there as well, Chair. So that's how I say it doesn't have to be a staccato step-by-step process, Chairperson. We can continue with the bill and so finalize the bill in the time that we wanted to have it, and allow the public the regional opportunity which they deserve, Chair. Thank you.
Okay, thanks. If that's the case, I think what we'll have to do is to amend the program that we have for this fourth quarter, so as to accommodate the pressure coming from the public. Probably in a day, we have a meeting in the morning as programmed to process other business. And as Alan suggests, after the sitting, we have another meeting to process this bill, so that we try to make sure that come the end of the year, we'll have processed all the issues that are in the program. But there is this matter of this bill, which also have to be given consideration. So, Alan, I think what we'll have to do, let's look at the program after this meeting and try to allocate dates for processing this bill after NA sittings. And as you have suggested, for instance, we can also sit on Thursdays. Look at the Thursdays that are there, even on Fridays, Friday morning. Allocate those dates for processing this bill. And I think by so doing, we'll be able to satisfy the request coming from the stakeholders and be able to meet the target in terms of time allocated to process this bill. Can we take it from there, honorable members, that will amend the program to try to have Thursdays and Fridays for processing this bill, while providing enough time for stakeholders to make another round of submissions. So we'll come back to the stakeholders after this meeting as to how much time are we allocating to them for further submissions while amending the committee program. Can we take it from there, honorable members?
Agreed, Chair.
Agreed.
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 Agreed, Chair.
Thanks, Honorable de Villiers. Achtbare predikant, are you still there, Steve?
Yes, no, I'm in agreement with that, Chair. That's trying to balance the different interests, but I do think if Treasury can come back quickly with a response to remove the Npo issue, I think we'll finalize the bill very quickly. Thank you, Chair.
Okay, so we'll look at the program with the team after this meeting and amend it so that it gets approved, and then send it to you as members so that you have to readjust your calendars, because you don't only belong to this committee. Some of you belong to other 2 or 3 committees, so that we don't inconvenience you. I hope stakeholders will also accept the approach that we are taking. Thanks very much. Do we have an announcement, Alan, before we close?
No, Chair, no announcement, except to say that the meeting of tomorrow is not going ahead. We couldn't get all the stakeholders together for now, so that will need to be done sometime later during the term. Thank you.
Okay. Thanks very much for that. So it means our next meeting will be next week, Tuesday. As I've already indicated in our my closing remarks, that we'll readjust the program of the committee to try to accommodate the issues or the concern of the stakeholders, to create more time for submissions. So we'll come back to you as to how much time are we allocating for you to make further submissions. However, we'll try by all means that that does not have a serious impact on the time frame allocated for processing the bill. We don't want to inconvenience our colleagues from the side of the NCOP. So we are going to work overtime to try to deal with this matter. Is it a legacy hand, or what is it that, are you raising a hand, Mr. Davidson Vukile, or it's a legacy hand?
Yes, Chair, but I just really wanted to thank you for your for coming up with this sort of compromise. I think it will be really useful. And we certainly, as the Honourable Swart, I think, mentioned, we will very urgently engage with the Npo sector to try come up with a solution. Even this week, we had already thought of some possible measures just listening today, and I think that will allow us to really speedily deal with some of the issues, even ahead of a very long extension. We could certainly do that very quickly. So thank you again, Chair, for allowing that flexibility.
Okay, thanks. Let's do like this, Treasurer. Please, next time, don't bring bills in Parliament that you want them to be processed in 1 month. It is not proper in terms of the spirit of participatory democracy. That from the side of Parliament is a compliance matter for us that we have looked at the bill and then let it pass. It should not be the case. Parliament is a legislative body, not departments. So don't stay sit with bills. Then right at the end, when you realize that you have to meet deadlines either from the Constitutional Court or from a regulatory body, then you drop the bill in Parliament. It's not right. And the typical example is what is happening now. Because what we are faced with is not our problem. It's the problem of the executive. So you put us in the fix. It's like now Parliament must take responsibility. No, the department must take responsibility for tabling the bill late. So we'll try everything in our power to make sure that we afford stakeholders enough time to make further submissions. What it means is that we are going to work overtime to make sure that we comply with the time frame that Parliament has set for us. Thanks very much, colleagues, stakeholders, everybody who's in the platform. The meeting is adjourned. We'll meet again next week, Tuesday. Thanks.
Thank you, Pastor Joe.
Bye, danke, my pastor.
Recording stopped.
Let's do like Alan, Frank, and your team. Can you please remain in the platform while members are leaving and stakeholders, so that we can discuss the program?
I am here.
Okay.
Thanks.
Alon, you are here.
Yeah.
Who else is up? Where's Tebo was here?
Tebogo, Beauty, and Zakele, and Nkululeko from the Select Committee is also here because obviously what we do is going to impact them.
Do we need to Do we need the YouTube stream? Sorry to interrupt.
No, we don't. This is a in-house matter. So
Yeah.
if Kira from PMG, Mike Pothier, Orateng Mutsoi, YouTube, Sipitelo, UPBO, don't think this is relevant for you, but yeah. And Ms. Nkomo, I mean, she's a member of the committee. She can stay if she wants. Chair, with your permission, should I just remove those that are not responsive?
Yes.
Okay, thanks.
I see the parliamentary YouTube streaming. Do we have